Drug supply on an ongoing basis is an offence under Section 25A of the Drug Misuse and Trafficking Act. It refers to situations where a person supplies a prohibited drug other than cannabis 3 or more times in the space of 30 days and obtains some financial or material benefit for that supply. So to be found guilty, the prosecution must prove 3 things beyond reasonable doubt. The first is that you supplied any prohibited drug other than cannabis. Secondly, that you supplied the drugs on 3 or more occasions over the course of 30 days. And finally, that you received some form of monetary or material benefit from it, such as cash, gifts, services, drugs, or even things like the promise of a promotion at work if you supplied on behalf of your employer. It's important to note that the drugs supplied can all be different. So for example, you don't need to have sold only heroin on those 3 or more occasions. You can still be charged if you sold speed, ice and heroin on 1 occasion over each 30-day period. Ongoing drug supply does not, however, include situations where you sell drugs for someone else as a favour and you don't receive any benefit, or where you give drugs to your friends or others for free. Ongoing drug supply is what's known as a strictly indictable offence, meaning that it can only be dealt with by higher courts such as the district or Supreme Courts. It cannot be finalised in the local court. The maximum penalty is 20 years imprisonment and/or a $385,000 fine, so it's considered to be a serious drug offence, and the law says that those who are guilty should be sent to prison unless they can show exceptional circumstances why they should not be sent away. For this reason, if you're charged with ongoing supply, it's vital to engage criminal defence lawyers with specialist experience and expertise in defending and winning serious drug cases. At Sydney Drug Lawyers, we have an outstanding track record of winning strictly indictable drug cases like ongoing supply. We're often able to get charges dropped at an early stage on the basis that the prosecution cannot prove 1 or more of the elements or ingredients of the offence beyond reasonable doubt. Alternatively, we may be able to get the case dropped on the basis that you have a valid legal defence, such as duress, which is where you were forced under threat to supply the drugs. Where the evidence against you is strong, we can work towards getting the charge downgraded to a far less serious charge, such as drug supply or even drug possession, so that you are unlikely to face a prison sentence. So don't delay. Call us now and speak to one of our specialist drug lawyers to find out how we can fight your ongoing supply charge.